Good evening, everybody. Welcome all of you in the World Record Series of Shri Kumarswami Mahavidyalaya, Ausa district, Latur. Today is the 18th day, and today we are going to listen about the IPR, Intellectual Property Rights. Today's resource person is Dr. G. Gabriel Prabhu, who is Assistant Professor in Commerce, SNMV, College of Arts Science, Malumachampatti, Coimbatore, Tamilnadu. The topic is related to our all educationalist, teachers, students, and so we are happy to learn more about the intellectual property rights from our today's resource person. I request Dr. G. Gabriel sir, please start your presentation. Thank you.
Thank you, sir. Good evening to all. I am Dr. G. Gabriel Prabhu. I am working as an assistant professor in commerce in SNMV College of Arts and Science, Malumachampatti, Coimbatore. Today we are going to see about IPR. IPR is nothing but intellectual property rights. Okay. Intellectual property rights is a product of the human intelligence, including creativity, concept, invention, industrial models, trademarks, songs, literature, symbol, names, brand, etc. If you are well known to search a new design or new concept or innovate anything new, so at the time we can easily get protect our innovation from the public. In India, there are different types of intellectual property which are protected under different laws. In order to register intellectual property, patent rights, copyrights, then trademark, lot of intellectual properties are available. Each one having their own. So we have to follow when we are going to apply for the IPR. Globally, two conventions constituting the basics for IPR system worldwide have been signed. First one is Paris Convention for the Protection of Industrial Property in 1883, and another one is Berne Convention for the Protection of Literacy and Artist Work in 1886. First one is patent. It is working the combination of four laws. First one is Patent Act 1970 and the Patent Amendment Act 2005, and third one is Patent Rules 2003, and last one is Patent Amendment Rules 2020. The four acts are protected our patent. We have to follow the four acts at the time of applying our patent from the IPR. A patent is a legal right that confers monopoly to a person for their invention. If anyone finding out their own invention, at the time we have to apply for our rights from the IPR. According to the Patent Act 1970, an invention must fulfill three criteria. What are the criteria? First one is it must be new product or a process that did not previously exist. And second one is it must offer a new technical improvement, as simple changes to a previously known technique can't be patented. It is a fully newly one. Then only we can able to get a patent from to others. Then they can use our patent. India grants patent rights on a first to apply basis. The application for a patent can be made by either the inventor or the assignee or the legal representative of the inventor. If you are the inventor, you can directly apply the application. Suppose I am not, I got some work, so I am not able to apply. At the time, I can appoint one legal representative for applying the process. And the patent application may also be made jointly by two or more corporates and assignees. A foreign national residents can also apply and obtain a patent in India. Now we can discuss whether the foreign nationals can apply patent in India. That is possible. Under the Act, Patent Act, everyone can easily apply for their own innovation. What are the registration procedure for getting the patent? And first one is patentable search. We have to find out the new things from the world. Once we get the new things, then we can go with the registration procedure. Next one is drafting the patent application. If an invention is found to be patentable following a search, the applicant must write a patent application that details the invention. The first step after drafting a patent application is to file the patent application. And third one is filing the patent application. The next step is filing the patent application. Applications must include the invention's specifications as well as any other necessary or patentable information. To obtain a patent registration for their innovations, an applicant may submit both provisionals and a full application. Suppose a government is asked to submit all the details regarding the patent, then the applicant must submit all the details regarding their new innovations. After that, the publication of the application. The IPO publishes the application in the official patent journal. Make it available in the public domain after 18 months from the date of filing or priority. If you want to get the earlier, at the time we have to give a request to the IPO office. On the basis of the request, they will publish early. It is possible. And next one is examination of application. After publication, the patent office examines the applications. Unlike publication, examination does not occur automatically upon file. Suppose sometimes it will publish and the examination automatically. If it is not done, then we have to give the request to the IPO office. And next one is objection by the examiners. If the examiners have any objection on the innovation, the applicant must explain and solve the objection raised by the examiner. Next one is office action response. The applicant must respond to the examiner's objection to receive a grant patent. They have a maximum of 6 months from the first examination report. If you want to extend our date, it is possible up to 3 months. It is available in IPO office on the basis of request raised by the applicant. And the last step is grant of patent registration. Once the applicant addresses all the objections raised by the examiner, the patent office grant the patent registration and publish it in the patent gazette. Now we are going to see about what are the documents you have to submit at the time of registration. First one is Form 1. In that Form 1, applications for grant of patent. We have to submit the identity proof of the inventor and assignee, and we have to submit address proof of the inventor. contact details, information corresponding to prior patent applications relating to the current innovation which the applicant or any authorized entity has filed. Some declarations and among other information we have to submit. In Form 2, we have to submit provisional or complete specification of our innovation. It is used to furnish the applicant's patent specification. It may be provisional or a complete patent specification depending on the type of patent applicable being filed. And we have to produce Form 3. It mentions that the statement and undertaking under Section 8, particulars of the assignment, and also details of foreign file. If there is any others, if there is any others are living in foreign countries, then we have to submit their details in this form. And the next one is Form 5, declaration as to inventorship. We have to give the applicant is used to declare the inventors of the current patent application. And technical information. In that technical information, we have to produce background of the invention and disclosure of the invention and summary of the invention, then the description of how the invention works. We have to produce detail. In Form 18, it requires for examination. At the time of examination, we have to submit this kind of forms. And the next step is Form 19. It is used for early publication. If the applicant wants to publish their innovation or new ideas in early, then at the time they have to produce Form 19 to the IPO office. And next one is disclosure of power of autonomy. If the applicants want to give their power of autonomy to someone, then we have to produce the Form 26. In that Form 26, we have to mention who is get the power of authority and their details we have to submit. And next one is request for publication. At the time, we have to produce Form 9 for requesting of patents. This is optional if the express publication is required. And next one is trademark. In trademark also having their own laws. Trademark Act 1999 and the Trademark Amendment Act 2010 and Trademark Rules 2003 and Trademark Rules 2017. Trademark is nothing but for a business is among its most valuable assets because it is used to identify our business. The company's trademark protects its distinctive sign or indicators. This may be a symbol or logo or word, phrase, name, sound, design or an image that symbolizes the brand value or goodwill associated with product and service. We can use the trademark among the or word, anything. For example, for Nokia company is using the connecting of it. This is a word to identify their company. So this kind of word or logo can be used. Next one is what are the procedures for registration of trademark? We have to conduct trademark search because trademark have not been used by anyone by the. If you are going to Indian Trademark Act, then we have to search among the Indian countries whether any trademark is used the same or not in various. After that, we have to filing the trademark application to the IPO office. What other procedures are following by the patent, we have to follow the same. This one is verification of applicant and documents. The IPO are requested to verify the requested to submit the documents for verification. At the time, the applicant should submit all the details. What are the details are asked by the IPO office for verification. Then the applicant must submit all the details to IPO office. Once the verification done, then the publication of trademark in the trademark journal by the IPO office. Then at the time we have to, if there is any queries arrested by the IPO office or objection arrested by the officers, at the time the responsibility to solve all the queries by the applicant. Once all the queries are solved, then automatically it will be go to the publication stage. Once the publication is done, then the grant is given by the IPO office or the registrar. These are the procedures to follow the trademark. What are the documents required for trademark registration in India? The applicants should submit their identity, whether it is PAN card or driving license or Aadhaar card or family card, anything for identity. Next one is PAN card. Next one is Aadhaar card, passport, then certificate of incorporation. It is applicable for company. If the company is going to register the trademark, at the time they are necessary to give the COI. The COI is certificate of incorporation. And logo, if it is applicable and available. If they are designing any new logo, that logo should be submitted to the IPO office. After that, they have to submit the address. Lot of proof are available. For example, electricity bill, telephone bill, anything we can able to submit the address to the IPO office. Next one is copyrights. Copyrights also having 3 laws. First one is Copyright Act 1957 and the Copyright Amendment Act 2012 and the Copyright Amendment Rules 2013. These are the acts comes under the copyright. India has a very strong and comprehensive copyright law based on the Indian Copyright Act of 1957. The copyright law is fully compatible with the international norms like the Berne Convention trade-related aspects of intellectual property rights agreement and the World Intellectual Property Organization and also World Copyright WC. The copyright grants the exclusive rights to the creators to control reproduction or adaptation of their work for a certain period of time. Unlike trademark and patent, a copyright protect the unique expression of ideas and not the idea itself. Further, copyright registration can't be obtained for title or names, short word combinations, slogans, short phrases, etc. What are the types of works is eligible for copyright registration? First one is artist work. Any kind of artist work, it is newly available. It's not available or is not available existed one. Our new innovation should be newly one. Then procedures for cinematography films and music voice recordings, literacy work, musical works including any accompanying verse, dramatic works including any accompanying music, phantom is just like drama and stereographic works. And last one is sound recordings, etc. These are the works is eligible to get a copyright registration. What are the procedure for getting the copyrights? We have to create a user ID and password at the official site, that is copyright.gov.in. Through that link we can create a ID and password. After that we have to file the application form to the IPO office. Once the application form is submitted, the IPO officers examine the application. It will take minimum of 30 days. Once the examination is done by the IPO side, some queries will be arranged by the registrar or IPO officers. So we have to solve all the queries. Once we solve all the queries raised by the IPO office, then the last step is they are issuing the registration certificate for our copyright. What are the documents required for copyrights? First is basic documents. Basic documents is name, address, and nationality of the author of the work. We have to produce the details for applicant name and applicant address, nationality, like that. And next one is disclosure of the applicant's interest in the copyright, whether they are the author of the work or the representative of the author, just like a power of attorney, that kind of. And third one is copies of the original work. We have to submit 2 copies to the IPO office. In case of business purpose, we have to produce the certificate of incorporation. And details of the nature of the work, we have to submit to the IPO office. And class, title, and description of our work, we have to give detail to the IPO office. And next one is language of the work. If you are producing any language, if you are innovating new things in language, then we have to give the detailed work to the IPO office. And date of publication. The publication in internal magazines or such paper submitted to the professors does not count as publication. For example, if you are working in any colleges who are preparing their own notes for our students, then it is also possible to get a copyright. We have to produce detailed application to the IPO office. They will examine. After that, they will give the certificate for copyright. Then artist work. If our work is related to artist work, at the time we have to produce the following documents: 2 copies of the work, then demand draft. We have to pay normal fees. It is arranged by the IPO office. It should be done by the applicant through demand draft. And next one is others no objection certificate. If the applicant is different from the others. If you are appointing any power of autonomy, then we have to produce the NOC certificate to the IPO office. Then publishers NOC if the word work published and publishers is different from the applicant. Search certificate from trademark office in trademark scheme. It is useful for our innovation is a new one. That one is given by the trademark office certificate. If the work is being used on goods or items capable of being used on the goods. NOC from the individual whose photography appears on the work. If there is any photograph appear in our work, we have to produce NOC from that photograph. And the next one is when filing the application by the attorney, an original copy of a power of attorney signed by the applicant and also asserted by the attorney. We have to produce the IPO office. In cinematography film, we have to produce the following documents: 2 copies of the work and a demand draft for payment. And next one is NOC from different copyright holders or copy of the agreement. And NOC from the publishers if the work published and the publisher is different from the applicant. If the applicant are different, we have to produce a NOC to the representative. When filing an application through an attorney, an original copy of the power of attorney signed by the applicant and also asserted by the attorney. If the work done by the music, then we have to produce the following documents: 2 copies of the work, same thing. Demand draft we have to taken in favor of IPO office. And NOC from the publishers if the work published and the publisher is different from the applicant. Others NOC. If we are using any others music, then we have to get the NOC from the others. And when filing an applicant by the attorney, an original copy of the power of autonomy is duly signed by the applicant and also accepted by the attorney. And the next one is software. Same thing, we have to produce 2 copies of the work and take the DD and submit it to the IPO office and get the NOC from the publishers if the work is published and the publishers is different from the applicant. And also if we are using any other software, then we have to get the NOC if the applicant is from the others. And as the same thing, when filing the application through an attorney, the original copy of the power of attorney signed by the applicant and also accepted by the attorney. The source code and the object code of the work for Q verification. And next one is industrial design. Industrial design is also working on the basis of 3 laws. First one is Design Act 2000 and Design Rules 2001 and Design Amendment Rules 2020. Design refers to the distinctive visual characters of an article such as its shape, figure, blueprints, decorations or arrangement of lines and colors or a combination of these created through any manufacturing method, whether manual or mechanical, automated, chemical or a combination thereof in either 2-dimensional or 3-dimensional form. If we are find out any new shape for manufacturing some commodities, it is also patternable by the Designing Act. The purpose of obtaining design registration under the Design Act is to protect a unique or innovative design that is presented by the applicant to the particular article during the manufacturing process using an industrial process or method. It is very useful for industrial people if they are having their own innovations. They can apply for patent through the Designing Act 2020. What are the procedure for getting the design grant? First one is we have to submit for examination. Once the design is submitted to the examination purpose, then it will be formally checked by the design IPO office. Once it is done by the IPO side, then substantive examination is done by the IP office. After that, they will produce the report, consideration of examination report. In that report, if they are arising any queries, then it is the responsibility to solve by the applicant. What are the queries are arrested by the IPO officers, they have to answer. Then design, registration and publication. After solving the all queries by the design be published by the IPR journal. It is available in the IPR website. I will laterally I will show the certificate and also journals. After that, the design will be registered by the IPR office. Then, what are the documents we have to produce to the IPR office? Form 1 should be filled out in the prescribed format as mentioned in Schedule 2 of the design rules. Next one is the representation must be prepared in accordance with rules 12, 13 and 14 of the design rules and submitted if to fill. And next one is if the applicant is filled through a patent agent or an advocate, Form 21 should be submitted. The power of autonomy or general power of authority should be submitted in the original. This form is also mentioned in Schedule 2. If a copy of the GPA means general power of authority, is filed, it should be endorsed with the design application number with which the original GPA was filled. Form 24 is the prescribed format should be submitted if the applicant is claiming small entity status as mentioned in Schedule 2 of the design rules. If the applicant is an Indian entity, the evidence of the registration under the MSME Act 2006 should be provided. In the case of foreign entities, an affidavit should be deposed by the applicant or the authorized signatory as per rules 42 of the designing. The original priority documents should be submitted under Rule 15 of the designing and authenticated English translated copy of the priority document should be submitted. If the original priority document is in a language other than, if you are producing the other language like Tamil, Hindi or any language, then we have to produce the translate. If the applicant for the priority application to the convention country is different from the Indian applicant, an assignment in the original format should be submitted. Now I will show some of the certificate received for the designing certificate. Registration. After that, the title of the design. Here, heavy metal identification flows using nanotechnology. What are the titles are given by the applicant? That applicants be placed here. After that, who are the innovators? Maximum, I think, 30 to 50 members can be joined in a design. Fine. All the details we mentioned, who are the designers, the innovators, their name should be placed here. These are the certificates for design. In Form 1, we have to produce all innovators' name and designation, place, each and everything we have to submit. These are the procedures followed for the purpose of getting the IPR from the IPR. If you are having any queries, they will ask. verified. Then after verification, they will give the certificate. This is the design for one of the design. For journal pattern, we have to submit our content to the IPO office. After, if we are having some diagram, then it is also included in the content. Thank you for your cooperation. This certificate is value up to 10 years. After that, if you want to renew, then we can able to renew. We have to pay some meager amount.
Thank you, sir,
Thank
for
you.
your wonderful presentation
Yes, sir,
on
thank
the
you.
topic intellectual property right, where you express all the views regarding the topic, artistic work, industrial designs, and other things. How is the procedure? So, I'm very thankful to you. Now I request dear participants, please, if you want to ask anything, please come ahead and discuss with keynote speaker. Please come.
हेलो, नमस्ते सर। सर, पहले तो मैं आपको ढेर सारी बधाई दूंगा कि ये विषय एक कॉमर्शियल विषय है और छोटे से बड़े से विषय जुड़ा हुआ है। जो ट्रेडमार्क की बात आती है, तो ये बहुत ही अच्छी जानकारी आपने दी पटल पर, उसके लिए बहुत बहुत धन्यवाद। दूसरा एक सवाल मैं पूछना चाहूँगा सर कि जो हम क्रोम या गूगल से
Can you speak in English, sir?
We can translate, sir. Please, he let
Okay,
him
sir.
speak.
Okay, sir. Okay, sir.
सर जो क्रोम या गूगल से लोगो हम ले लेते हैं, क्या वो उचित रहेगा या खुद का अपना लोगो तैयार करना चाहिए?
Sir, he is asking for the logos which are available on internet, Google, all these things. Can we take as it is, or it is illegal one using others' logo? He is asking about that.
Sir, 1 minute, sir.
Yes, dear participant.
Mr. Gabriel, this is Badiuddin Ahmad from Hyderabad.
Please.
Hello.
Tell me, sir.
Yes, sir, we are getting. Please speak.
Sir, did you get the translation from Bedkar sir, Mr. Gabriel?
Yeah, tell me, sir. Now you translate, sir.
He is asking about whether can we get this logo directly from Google that or something else. Is it legal or having any implications?
Yes, logo. If the logo is new innovated by yourself, then it is searched by the IPO office. You have to submit your logo to IPR office, and the IPR officers are searching if the same logo is available or it is used by already used existing one. Then
You mean to say that you should have our own creation, not copying from any source?
yes, sir. We are not able to copy from any other sources. It is a new innovation found out by the applicant. At the time only we can able to get a grant.
Oh, okay. Thank you so much. Thank you so much. जयवीर जी, आप समझ गए होंगे ना जयवीर जी?
समझ गया सर, धन्यवाद सर।
Thank you so much. Mr. Gabriel, my question is that how difficult is to get the IPR in the social science or commerce and management? Because I belong to commerce and management degree, and if I go for patent, what really we can individual things we can do, because everything is not unlike in the computer science, in the physics, in the chemistry we can do. But what about social science, especially commerce and management? I belong to commerce and management stream.
Okay, sir.
Could you guide me?
Commerce, in commerce management, new methods. If in business, if you are find out any new techniques, or in agricultural, new technology for a combination of some more commodities, like that. If you are find out any new things, then you can able to apply for IPR. It is a patentable one. Whether it is a business, in business you can find out any innovations, methods how to improve the techniques of business development.
Can we have the collaborative type of IPR can file like with the computer department or with the
You have to collaborate with the computer science department, and then you can make any software. For example, in billing, you can find out any new software. At the time, it is also patentable because lot of billing systems are available. If you are find out new thing, then it is also patentable.
If we develop certain package for the software for with using accountancy or something else, we can file jointly I think with the computer science department.
Yes, sir. Recently, Tally plays a vital role. If you are innovated new software related to Tally, then it is patentable.
Thank you so much, sir. Thank you, sir. I got it. Thank you so much, sir.
Thank you, sir. Thank you.
Sir, will you please on your camera because direct communication is available here. Up till now, presentation we don't expect that, but now you are connecting with the others. Okay. Thank you.
Okay. Thank you, sir.
Swanand Shukla, sir, please.
Yes. Good evening, sir. Good evening, sir. My question is, in the academics, we are doing a lot of research, and especially in the medical field. So with the clinical cases and clinical aspects we are learning and case studies we are making. Now over here we are using some scales for measurement and for calibrations. So many of the times these scales are available on Google and various other media. But the thing is, we have to take a permission because it is an intellectual property right. And we are sending mail to them. But those people are not reverting to those mails. So at such an instant, what we can do, because otherwise it may be a violation of, what we can say, intellectual property right. So how we can consider it and when we should consider it, if they are not responding, if they are not giving, we can use it or we cannot use it. What do you say, sir, about this? Thank you.
Okay, sir. You have to make a request to particular persons, and sometimes they will expect some monetary benefits from your side. For example, if you get a patent and making a product or a commodities like that, it is circulated in the market. Through that one, you will get some benefits, profits, anything. Through monetary or any other format, you will get some benefits. In that monetary benefit, they will you have to give some ratios to particular person.
But usually sir, sorry to disturb you, but usually when we are going for academics, many of the times it is free of cost. It is mentioned over there. And still we are sending them mail that we are going to use this because we don't want to use it, like that. So, but the response, we are expecting they will revert back the mail if they will say yes for academic purpose, you use it. And usually they are not doing it, and then sometimes we are proceeding with the same scale. So whether it is a violation of IPR?
Yes, sir. It is possible to take any action if you are using without permission. If you are using the without permission their own rights, then it is chance to make some actions against.
Sir, next question is for the copyrights. If suppose I am writing an article or some concept and I want to make it get it copyrighted, so just by putting C and round it is okay, or whether it is I have to apply somewhere.
Sorry, sir. One second. Hello, sir. Hello.
Sir, my question is, if suppose I am writing some article or I am having some kind of concept in front of me, and I want to get it copyrighted because no one should use this idea or concept further. So whether there is any procedure for copyright the thing also, or we have to just write C and that round.
It is newly just you will take some concept from that previous one and making a new things. After making a new things, you will go with the IPR sections. You have to produce all the copies to the IPR office. After that, they will come in and they will give that.
Okay, sir.
You can't use the full text, materials from that.
My new concept is my new concept, new thing I'm coming with, and then I want to, I want to protect it with the copyright. So what is the procedure? I have to go with IPR or technique only.
Yes, you have to submit your work to the IPO office in detail. You have to fill the application and submit to the IPO office. They will examine. After that, if any queries, they will ask to you. You have to solve that queries. Then your work is done.
Okay, sir. Thank you. Thank you for a wonderful presentation, sir. In a well depth you have talked about and various formats and this illustrations what you are given. Definitely, if you can put it on a group with the help of our principal, sir, so that will be helpful for us also for our study, sir. Thank you.
Thank you, sir.
Thank you, sir, for asking, discussing here. Sir, my question is, if we registered a design on a particular day, then what will be the time of getting the grant to our design patent, sir?
Sir, if you go with the normal registration, it will take minimum 1 year, sir. Minimum 1 year, maximum 1.5 years.
Okay, thank you.
Takkal is available. If you are going with Takkal, then 5 to 6 months you will get the grant.
Okay, thank you.
Thank you, Dr. Badiuddin sir, Dr. Swanand Shukla sir, Dr. Jaivir Singh sir, and Honorable Principal sir, for your wonderful questions and keynote speaker. You have answered it very well. Now I request the Chief Organizer of the World Record Series 2, our ideal Principal M.M. Bedkar sir, please give some words for us. Please come, sir.
Thank you, Prashant Ugade sir. Today's resource person, Dr. Gabriel Prabhu sir. All the participants, Dr. Badiuddin sir, Dr. Swanand Shukla sir, Jaivir ji, all my staff colleagues, Dr. Kale sir, Professor Kale sir, Professor K.N. Kadam sir, Dr. Anta Dhole madam, and all regular joining participants. It was a great experience to learn about IPR with the expertise like Prabhu sir, and he explained everything which was also new for me. What is the registration of process of IPR, means copyright, what is the designing allotment of designing registration, what is the process of filing the patent. So all these things are very useful to us, those who are here as an academician like Badiuddin Ahmed sir, Swanand Shukla sir, those who are doing some innovative thing in this field, they can apply for their consult patent or designs as per their output or the service copyright, all these things. Thank you sir for joining here, for giving best information about intellectual property rights. It's very useful to all academicians, to us also, and in future also if you have any new concept with you like subject, then you are always welcome on this dais. Thank you and keep joining. Also recommend some resource person for discussing here as like you as a resource person. Thank you sir.
Thank you so much, sir. Thank you to all.
Thank you very much, sir.
Thank you, sir. Thank you so much. Thank you to all.
Towards over the thanks, Shri Kumarswami Mahavidyalaya Ausa have organized the World Record Series 2. So today was the 18th day of this record series, and the keynote speaker, who was Dr. Gabriel Prabhu sir from Tamilnadu, who have given the wonderful speech on the topic intellectual property right, where sir have explained what we mean by IPR, then what are the things are included in IPR and different types of the IPR, and explain with many examples. So I am very thankful to you for the presentation, sir. We expected you appreciated a lot. Thanks a lot.
Thank you, sir.
I am very thankful to Chief Organizer of the World Record Series 2, Honorable M. Bedkar sir, for giving us concluding words. Thank you very much. Now some of the colleagues from my college, Dr. Anita Dole Madam, IQAP Coordinator Dr. Sanjay Kale sir, and other colleagues, I also thankful to you. And the daily joint participants, Dr. Badiuddin sir, Swanand Shukla sir, Jaivir Singh sir, who always discuss with the speakers and enhance the beauty of the series. So I am thankful to you for sharing your views in discussion session. And lastly, I am very thankful to all dear participants who daily joins on the time and give their valuable time and discuss the benefits of the series. So thankful to you all. Now I request all the participants, please fill the feedback link which is given in the chat box. So please take it forward with the kind permission of Honorable.
Thank you, sir. Thank you, sir. Thank you, sir.
Thanks to all. Thank you, Gabriel sir. Very nice
Thank you, sir.
for paying
Thank
us
you,
valuable time. Thank you.
Thank you to all. Thank you to all. Thank you for your wonderful opportunity. Thank you.
Have a nice day, sir.
Good night.
Thank you.